Hello and a warm welcome to another video. And if we've not met before, my name is Ian Wormsley and I am the founder of Planning Geek. And today on this video, I am going to be talking all about Article 4s. So this video will be very much an introduction to Article 4s, what they are, what they can block, and what to do if the local authority decides to issue an Article 4 almost overnight in your area, which unfortunately has happened recently to one or two areas. But don't panic. I'll explain exactly what to do and what an Article 4 is. Okay, so if we've not actually met before, you may not know about Planning Geek. And Planning Geek is a website that has been in existence now for around about 8 years. We now undertake planning applications across the UK with my team of consultants, highways engineers, architectural people, etc., etc. And we do quite a few applications per year. And unfortunately, we have to deal with Article 4s on an increasingly more common basis these days. But what are they? So let's go back a step or two. So an Article 4 is something that can block permitted development rights. And you need to understand what a permitted development right is, first of all. So if you want to, say, build an extension, you want to put up a garden fence, although not so common perhaps these days, if Sky comes along and erects a satellite dish, all these things are permitted development rights, and these are all contained within what is called the General Permitted Development Order, and that was last revised in 2015, but it's been amended many times over the last 10 years or so. So you've got all these PD rights. Now, local authorities, I will be honest and say they're not fans of permitted development rights. They would much rather control development. They would much rather say where you can do these things, where you can put on extensions, where you can change to HMOs, for example. And that is a hot topic at the moment. And so they do have a right to block an awful lot of permitted development rights. And these are via a piece of legislation. It's actually the fourth article within the GPDO. And that is called Article 4 Directions. Nice and simple, you may think. Okay, so the local authority normally has 12 months or so to bring this in. The normal process is a local authority will decide via an executive board meeting or whatever it might be within that borough, and they will decide to potentially bring in an Article 4 in the future. Now, what they would normally do would be to go out to consultation and allow local residents to comment as to whether or not they ought to introduce this Article 4. And when the consultation comes back and says, yes, we all want an Article 4 in the area, the councillors will then say, okay, we're going to introduce an Article 4, and it will come into effect in 12 months' time. That is the correct procedure, as far as I'm concerned, for introducing an Article 4. Now, if they deem it to be urgent, if there is some important reason as to why an Article 4 should come in immediately, then they have that power. Now, in the past, that may have been to stop a particular development or a particular thing from happening that had a detrimental effect, if you like, on maybe a field, maybe a building, maybe something else within the borough where they were keen to put a stop to it pretty immediately. And so there is a right for a local authority to introduce an immediate Article 4. Now, if they do that, they must confirm that Article 4 in 6 months' time. That doesn't change, and they can do that. Now, that is the way to go about things. Unfortunately, what we are finding is that certain local authorities, especially to do with HMOs, are increasingly deciding to introduce an immediate Article 4. And often these will take effect from the same evening or the following morning. So there is no real warning to local residents or to developers or investors or even homeowners that these rules are about to change. However, there is a sting in the tail as far as local authorities are concerned, and that is down to compensation. And so on my site, I do have a information about compensation. That link has come up on the screen and will be in the description below as well. And in effect, when an immediate Article 4 is brought in, or where there is a lack of a notice, less than 12 months notice of the Article 4 coming into effect, then the local authority is subject to compensation claims by anybody. Okay. Now, when I say anybody, it's those people who have submitted a planning application within 12 months of that direction coming into effect. Okay. So let's say, for example, today is the 1st of May, 2026. Okay. As long as, and that's when the direction comes into effect, as long as a planning application is submitted on or before the 30th of April 2027, then those are subject to compensation. And you can claim for things like out-of-pocket expenses. So normally under PD for an HMO, say, you do not have any real expenses, and you can just do it as soon as you move your third person in. It becomes a C4 HMO automatically. But if you've got to submit a planning application, then you may have drawings. You would have the planning application fee. You may have a planning consultant like Planning Geek to submit the application for you. If you fail to get that planning through, if it gets refused, then you may have expenses such as loss of earnings, loss of value on the property. All these are something that can adversely affect the applicant, and as a result of that, compensation could be payable, and it could be quite a sizable amount to the applicant who has had their PD rights removed or not enough notice given of that. Because let's face it, people have plans. You don't just suddenly decide to wake up on a Monday morning, or not normally, wake up on a Monday morning and say, oh, I'm going to convert this building into an HMO. No, you tend to have these plans in advance. You may well have got a loan on that building, on that house to convert, or whatever your plans may be. But it's not just HMOs. It could be, for example, converting from offices to residential under Class MA. It could be as simple as putting up a garden fence. So, for example, in the village of Snows Hill, they have recently introduced an Article 4 blocking an awful lot of PD rights, things like fences, altering windows, doing many things, putting driveways in, stuff like this, which is a PD right. So there are an awful lot of things blocked in that village. And yes, if you're adversely affected, and there's not enough notice, you can claim compensation. So let's have a quick look at my website. And if I go over to my other screen here, you will see if you actually go to the Article 4 page, and I'll just bring that link up again on your screen, and it will be in the information below. You'll come to this page, and within this section, I actually describe in words as to what an Article 4 is, going to conservation areas and stuff like that, where you may find an Article 4 preventing certain PD rights like fences, windows, stuff like that. Within this section, we do have an HMO map, and that URL is also coming up on your screen now, a short URL to go to that. Now, within this section, I list every single Article 4 within England that is preventing HMOs. And I try and do this, I try and keep this up to date almost immediately as soon as a local authority makes a decision. And it is something that we watch every local authority around England just to see when these things change. And At the date of the recording of this video, we've got a few Article 4s about to come in. So in a few days' time, we've got Wakefield coming in, Ealing, Oldham, Fenland. There is a one in Swale, but we don't yet have a date for that. And a few others. Recently, you will see Tameside recently bought one in, Walsall, Hulton, Chorley, Rossendale, Wigan. So quite a few sort of northern or sort of Midlands area local authorities. But these are spread right across. So Eastbourne down in Sussex, they recently bought in an Article 4. Now on this page where you will see this indicator, this indicates immediate Article 4s or where they haven't given 12 months notice. And so as I said earlier, this is then subject to compensation. Now, what you may find is that a local authority will introduce introduce both an immediate and a non-immediate Article 4. So Ealing was a good example of that. So they introduced an immediate Article 4 on the 30th of October 2024. And by the way, you can download the directions and a map from this site for every single local authority that has an Article 4 direction in place or is about to bring one in. So, for example, with Ealing, as I said, they bought an immediate one in on the 30th of October 2024, which meant that anybody submitting a planning application before the 29th of October 2025, which is a week or so away at the time of this recording, is subject to compensation claims if they have out-of-pocket expenses. They also introduced a non-immediate Article 4, and that's above this line at the moment, and that is coming into effect on the 14th of November 2025, and there is no compensation payable for the rest of the area. The immediate one was in Perivale, and the rest is the rest of the Ealing Borough. So that is a good way for perhaps local authorities to do it, as opposed to other ones which may introduce an immediate Article 4 across the entire borough. And unfortunately, there's been a few of those recently that have introduced those virtually overnight. So this is HMOs. Now, Class MAs can also be blocked via Article 4s. And again, I'm just bringing that link up on the screen and you'll find that in the description below. So this blocks Class MA, Use Class E to residential. And again, there are many local authorities across the country that are blocking these. Quite often these, however, you'll find that these are specific against certain buildings. Under the last government, we did find quite a few local authorities introducing these Class MA Article 4s, but they were often, well, initially they were put in borough-wide, and then the Secretary of State said, nope, you can't do it borough-wide, you must do it for specific buildings. And so the Secretary of State can always intervene on a Article 4 and can say, he or she can say, no, I don't agree with this is unfair. And this has certainly been the case quite often with commercial conversions, if you like, under Class MA. And so what you will find is that local authorities have had to reintroduce different Article 4s, of which they can all be downloaded from the Planning Geek website. And you will find that individual buildings are listed quite often on these maps. Now, it's just worth mentioning also, especially with Class MA Article 4s, that they aren't a solid blocking for every single commercial conversion. So just bring it down to a couple of examples. So City of London, for example. So City of London introduced theirs on the 1st of August 2022. However, it only blocks offices. to residential. It does not block shops. It does not block light development. It does not block restaurants, for example. It only blocks offices. So just because an area has an Article 4, you have to make sure that you know specifically exactly what it blocks. Don't just assume that, oh, this has an Article 4 area, therefore I can't do Class MA. You may well be able to do so. And on the Planning Geek website, I do try and list within the description on the page on this table as to exactly what it does block. Where it's just got a direction, then it will block anything within the Class MA within Use Class E. So, but there are exceptions. For example, Broxbourne is town centre ground floor only. So it's not blocking upper floors at all. So in Broxbourne, yeah, you can most certainly do Class MA on anything above the ground floor. For the ground floor, you're going to need planning permission in the areas where it's blocked. So that's Class MA. I've already mentioned the compensation, but I will refer to that once again. And you can find out on that page as to what you can claim, when you can claim, and the process for doing that. And should you also have the necessity to appeal, again, I've got information on that. But what about an incoming Article 4? So if you've got an Article 4 that's incoming, then yes, you need to make sure that you are ready. And the best advice I can actually give is that if you've got an Article 4 coming in, then you need to make sure that you have 3 or more tenants on separate ASTs on the day before the Article 4 comes into place and the day after. Now, there is a little bit of case law that we might be able to use to argue the case that that if you've actually converted the property but not actually moved people in, that might be sufficient. But it's on a case-by-case basis. So, but you just need to be aware of that. Most certainly, we can assist at Planning Geek for that. And perhaps I've also got a page here on buying an HMO in an Article 4 area. What to look for. So on this, for example, I would recommend that you get the owner who's selling to be able to prove, or ideally get a certificate of lawfulness to confirm that either they've had an Article 4 there for at least 10 years, or they can prove that the HMO came in as a C4 HMO the day before, or at least before the Article 4 came into play. So you just need to make sure of that. But again, I've got all that information on my website. So that's the Article 4 section of the Planning Geek website. I try and keep it up to date. It's updated on a pretty regular basis. And if you want more information on that with the links I've discussed, you will find that in the description below. If you've got any questions on Article 4 or any comments or anything else, then, please do add your comments below this video. I will aim to respond to them all. And if you've got any questions, then please, ask them away, and we will answer them. I will aim to answer them below. Alternatively, I may well answer them on a future video here on this channel. But if you don't follow us, and if you've not actually subscribed, please do so. Please like this video and subscribe to my channel. It does make a difference when you like a video. It does, having that thumbs up. I know people always say that, but it does make a big difference and helps me to bring more videos to you. And now that I'm back in business, unfortunately, I had 3 months off. 3 or 4 months off because unfortunately my wife and I were involved in an accident back in June. We were knocked down by cars. So unfortunately things haven't been as regular as I'd like, but I'm back now, coming back in force. And yes, it's good to be back in front of a camera in my studio here. So look, if I can help you in any way, please do let me know. You can visit me, as I say, at planninggeek.co.uk. We are here to help you. I have a team of around about 15, 16 consultants that do planning applications across the UK. There isn't one borough that we do not work in. We do work across the UK, and we also have a highways consultant, architectural people, etc., that can deal with any issues or any problems or anything else that may arise. So we are set up to deal with absolutely anything from residential to commercial to agricultural. You name it, we can do it, and we've got good experience and well over 90% success rate for planning applications, which is something I'm quite proud of, actually, to be honest, because we don't take on applications just for the sake of it. We do them on, where we think clients have got a good chance of success. So until next time, we are here for you and to help you. So to the next video, I wish you a pleasant week or whatever, and we will chat soon. Take care, all the best. Bye bye now.